Welcome to the third episode of Season 2 of the Build Your People podcast with Kathy Humm. I'm your co-host, Jenn Dewees, and as always, I'm also the president of the Maryland Center for Construction, Education, and Innovation. At MCCI, our mission is to inspire, educate, and connect a diverse population to careers in the built environment. We've got a pretty interesting podcast for you all today. Our guest, Suzanne Decker of Miles and Stockbridge, she is an employment attorney. And Suzanne, Kathy, and I spend the next half hour or so talking about some pretty amazing conversations around compliance law, which may not seem like, a groundbreaking topic, but it really, there's so much that construction owners need to deal with in 2024 in Maryland. We're talking about the legalization of marijuana and its implications on hiring and workforce. We talk about prevailing wages and paying those and how to make sure that you're still competitive. We're talking about undocumented workers and how we can employ them. Can we employ them? And we even talk about sexual harassment in the construction space. So with that, let's get into it. This episode of the Build Your People podcast is brought to you by our sponsor, Carter Machinery. From humble beginnings in Southwest Virginia, Carter Machinery has expanded its footprint to over 30 locations across Virginia, West Virginia, Maryland, Delaware, and the District of Columbia. With a team of more than 2,300 professionals, they passionately sell and support the full line of Caterpillar equipment, engines, and electrical power generation systems. Their mission is to be an integral partner employing the latest technologies, data insights, and application expertise. Everyone defines their own highest level of success. Carter Machinery embodies a commitment to understanding and supporting those unique goals. Welcome to the third episode of Season 2 of the Build Your People podcast with Kathy Humm. I'm your co-host, Jenn Dewees, and I'm also the president of the Maryland Center for Construction, Education, and Innovation, or MCCEI. Our mission is to inspire, educate, and connect a diverse population to careers in the built environment. As always, with me is our podcast co-host, Kathy Humm. She's an HR professional and founder of NTP HR LLC. Hi, Kathy. How are you today?
I'm doing well. How are you doing, Jenn?
Wonderful. It's beautiful weather we're having here today.
80 degrees. Can't beat that.
Absolutely. Love it. Kathy and I have a guest today with us, Suzanne Decker of Miles and Stockbridge. Suzanne, will you take a moment to introduce yourself and give us a brief overview of your business and the services you offer?
Sure. Well, first off, thanks to you, Jennifer and Kathy, for having me today. I'm excited to chat with you about employment law. My name's Suzanne Decker. I am a partner at the law firm of Miles and Stockbridge, and I specialize in labor and employment, and I represent clients with employees of all sizes.
Awesome. So as you alluded to, we will be talking about employment and compliance law and its importance and what steps employers need to be taking to make sure that they are legally accountable here in the state of Maryland. So, like I said, last episode, we talked about succession plans and how business owners need them to effectively run their businesses. And today we're going to pivot a little and talk about what specifically Maryland construction business owners need to be worrying about and how how the laws could affect their businesses. And I know we've had a lot of new regulations happen here in Maryland. Kathy, before we get started, is there anything you want to talk about that you're seeing with your clients?
Well, I have to tell a funny story to start. I was doing my summary and recommendations with a potential client, and at the top of the list were 3 federal laws that they weren't complying with, over 100 employees. And the executive looked at me and said, "Well, they're not asking for it." And I said, "Well, doesn't matter, because if you're audited, this is what it's going to cost you." And he said, "Oh, leave it on there as something he had to do to be in compliance. So it's interesting. A lot of companies, what they don't know, it's ignorance is bliss, and they're not complying with federal, state, local regulations. And it's really important. So it's important from an HR perspective for us to shed light on, these are the things you have to comply with. And if you don't, this is the risk you take for the organization.
And I guess, speaking as an HR professional, there may be like thresholds of number of employees that are like I think, and I could be wrong, but FMLA, for example, is under what, over 50 employees? Is that what it
Mhm.
is?
Mhm.
Are there other
So there's
similar
different
thresholds?
thresholds. Over 50 FMLA, you have to do ACA reporting. If you're over 100, it's EEO1 reporting. And those are the things that I'm looking for when I'm going in and consulting with clients. When you hit those thresholds, you need to make sure you need to do this and that and the other. And a lot of times you just can point them in the right direction. So EEO1, they have a website where you can go to and you can actually do the report, and it's automated, but just making sure that they're doing it.
Awesome. Now, I know when we were prepping for this episode, we didn't really get into that type of compliance law. So, Kathy, when we wrap up and I ask my questions of Suzanne, there might, or even if we're in the middle of this and you think there's some questions or there's some laws that we need to be hitting on, because I think we were trying to get a little more exciting than talking about EEO
Yeah.
compliance and whatnot. So, with that, Suzanne, when we were talking, the big thing every high school teacher that we talk to wants to talk about, every person was like, what about marijuana? Right? In Maryland, it's obviously legal, but it is still federally illegal. And there's the whole just the safety aspect. Like you can obviously test if someone's drinking on that job. You can't test how recently. So how should construction employers navigate the legality of marijuana when considering hiring practices, especially regarding drug testing and workplace policies?
Sure. It's I would say the hottest topic that I get questions about is what about cannabis at work? So in Maryland, recreational use is legal, but you as the employer don't have to permit that. And I think you have to the employer's balancing a bunch of different things here, which is I as a construction employer in Maryland can do drug testing of my employees. I can do it pre-employment, and I can do it once employees start based on reasonable suspicion that I might have about somebody being under the influence of something at work. I think what the balance is for some of my clients is if I do pre-employment and I decide I'm going to screen out anybody with a positive THC result, that's a lot of my potential workforce. And so, do I have a concern about this group of people? And look, some people may. So, and then you fast forward to I've got a safety sensitive work environment where people may be engaging with one another. And so, what I see is sort of this balance between is it worth it for me to do pre employment? And then once we get into the workplace, if someone has an injury or appears intoxicated at work and I test and nothing else is positive except for THC, what do I, as the employer, want to do about it? And what I suggest is you have a pretty good idea of what you want to do about it before anyone ever tests positive, because it'll either
Oh, I think we might have lost her sound.
Yeah.
Lost your sound, Suzanne.
Can't hear you.
are
Up, you're back.
Okay, I apologize.
That's okay.
My phone is now silenced. I didn't realize that was going to happen. Okay, so my answer is it's either going to be your best employee or your worst employee who tests positive, and you may have a different feeling about each, and you just want to be able to be consistent because you don't want to fall into the issue of discriminating. Now, that's just in Maryland. If you've got employees on a job site in the District of Columbia, it could be a little bit different. In DC, you're not allowed to terminate just because of a positive THC result if they aren't otherwise showing signs of being under the influence. In Maryland, you still can. There was legislation this year that was going to stand in the way of what an employer could do with someone who tests positive, but it didn't pass. I would expect it to pass next year. And so, you've got to think about where your worker is when you see the behavior. But for now, you're fine in Maryland. There's always going to be a carve out for safety sensitive positions, though. And an active construction site is considered a safety sensitive location under most of the kind of recreational laws that we're seeing across the country.
Yeah, I think it's interesting because when I think of the people that maybe 10 years ago we would have thought that were using marijuana, I think there were probably way more people than we assumed. But now, with it being legal, I know people of all walks of life, grandmothers that can't sleep at night. And I have a lot of friends that use it just to help with that, like the sleeping part at night, or anxiety, or like millions of, not just recreationally using it for legitimate reasons. But you're right. I mean, it's until the testing catches up with, like, the blood alcohol testing, I think it's going to be impossible. But
it's interesting because
I wouldn't want to be a construction business owner right now.
No, it's interesting. A few states have said that there can't be testing of employees for THC until the testing gets sophisticated enough to determine if you're under the influence at work. And nobody really knows because you don't know how fast somebody metabolizes. Right. We've seen interesting technology out there to try to look at whether someone's under the influence. There's sort of this VR technology and whether it can tell whether you're prepared and ready to come to work, but it's really not foolproof at this point. So again, it's stepping back and deciding what's best for your business and how much risk are you willing to take?
And I would say in the construction space, for years, they've been really strict and hard line about we're testing for drugs to include THC. And if an individual doesn't pass the drug test, we're not hiring. Well, now, it's important to be more flexible with that. And what I mean by that is, you have medical marijuana card users, and if they're coming to the table, to work for your company, think about things like, what is the position? Is it in a safety sensitive position? Could we hire this individual if they're in the office? And really kind of think outside of the box, because let's face it, as we've talked before, Jen, on the podcast here, the workforce is shrinking. And if you eliminate all of these people who are users, whether they have medical marijuana card or not, it just shrinks the pool. And that's an issue in and of itself.
100%. Yeah. Well, we can pivot to another fun topic. So obviously in the construction industry, we're a very male dominated industry in that women only make up 14-ish% here in Baltimore anyway. But that also includes, that's tradeswomen. You get to tradeswomen, you're like at 4%. So women, obviously, having them on a job site is still not as commonplace as we would like it to be. And these women are facing barriers such as sexual harassment issues in the workplace. So for a construction owner that's looking to diversify their workforce and make sure that everyone feels welcome, what are some steps they can take to prevent sexual harassment and address any incidents that do arise?
So I'll take the legal aspect and then Kathy can come behind. This is a topic near and dear to our heart, right? Which
Mhm.
is how do we create an environment that's a lot more inclusive of people being and that people want to show up for work, right? So you start with where are you hiring people from such that you can source a diverse group of workers. You can source more women workers, but the only way it's really going to be a success and you can avoid the claims is if you have policies in place that kind of spell out what's going to be prohibited, that spell out where you need to go to raise your concern and how the company is going to react. And then the company has to react.
Mhm.
It's not enough to say, that's just Joe. Joe makes comments that are inappropriate and offensive to everybody. You know, that woman worker shouldn't worry so much about it. He's obnoxious to everyone. That's just not acceptable any longer if if you're gonna make your workforce more diverse. And so you've got to be training your supervisors and your managers about what behavior is going to be permitted or not permitted on the workplace and what their obligation is to step in, because on a construction site there isn't always HR right there like you might have in an office setting. And so you really do need to be training a lot of different people to be able to respond, because the most critical piece is that you responded and you did something about it. Doesn't mean everybody needs to be fired, doesn't mean any of that. It just means that we have to show that we took action to stop the behavior from happening in the future. And look, sometimes that's firing somebody, and sometimes it's pulling them aside and giving them a stern lecture.
You know, several years ago, Suzanne, you did a presentation on harassment training for the GC I was working for. And one of the biggest takeaways from that most of the employees got was that if you're a manager and you know something, you need to do something about it.
Right.
And I remember after you did your presentation, there was a situation in the workforce where a woman felt harassed, went to her manager, but she didn't want him to do anything about it. So he came to me and said, "Look, Suzanne said, when I know something, I need to report it. So tag, you're it. I'm reporting it to you." And so we kind of talked through the scenario and how this individual didn't want to get anybody in trouble. So I suggested to him that he walk, past this individual on the job site and just casually say, "Look, I overheard what you said or did to this individual, and that won't happen on my job site again. So if that ever happens again," and it nipped it, but we instead of throwing her under the bus, and she didn't want, but we nipped it right away, and it worked. But
It
it was
is.
great that he came to me and he said, "Look, I know this, but she doesn't want me to do anything. So what do I do?"
It's
Suzanne, maybe you can
super,
piggyback on that.
yeah. It's super awkward when the employee comes forward and says, I just want you to know, but I don't want anything to
Yeah,
happen. The
do
fact of the
something.
matter is, legally, as soon as you know, it says if a manager knows, the company knows. So you've got to take action.
Mhm.
And while the employee may have said, I don't want you to do anything about it, I don't want you to, she wouldn't have brought it forward if she didn't want something done about it. I think she's she's in an awkward position where she doesn't want to look like a complainer. She doesn't want to look like a troublemaker on a job site with fewer females. But at the end of the day, she raised the issue with the manager because she wanted something done. But I love the scenario that you give, Kathy, which is it wasn't making a big to do about it. It wasn't necessarily a big investigation that needed to be performed for the scenario that came up. it was pulling the guy aside and saying, I heard you. And I think it's really creating tools for managers to be able to jump in and be that person.
Mm-hmm.
Sometimes it's even as a joke. I saw what you did, that was offensive, or,
Can't
you can
happen again.
diffuse it
Mhm.
in so many different ways without it feeling so disciplinary or being in a way that the employee's not listening, right?
Hmm?
Yeah,
Yeah.
I've been a woman on a job site. I know what it's like to, it's still a man's world on a
Mhm.
job site. And I know what it's like to not want to like stick out any more than you're already sticking out and make it seem like you're a special case for anything. I understand that. But you're right, making sure that women feel supported and that they can have a place to go forward. Maybe they
Mhm.
don't feel comfortable going to their manager. Is there a hotline they can report things to?
Mhm.
Because maybe their manager's the problem.
Correct. So there should always be two ways to report at a minimum, whether it's to HR, it's an office manager, it's a job superintendent, multiple avenues to bring it forward, because it actually only takes addressing it a few times before the whole workforce begins to kind of get on board. But you gotta nip at it a couple times, and then people begin to remember, and they may act, kind of ridiculous. I got to be quiet. Oh, I'm not allowed to joke here at work. Yes, that's true. We are with people we work with more than we are with our spouses and our families, but we still need to behave. And that doesn't mean that every joke needs to be so offensive.
Yeah. Yeah. Hmm. I could probably spend a whole episode talking just about what women in construction face. Maybe we'll do that sometime, Kathy.
Yeah. Yeah.
But in the meantime, well, we'll pivot to prevailing wage, right? One, I guess, could one of you explain what prevailing wages to those that might not
Sure,
know?
sure. So for anybody who doesn't know, a prevailing wage are the wages that have to be paid on jobs that are paid with either state or federal money. And so what it means is if you are on a contract or a construction site that's got federal or state dollars associated with it, the state or the federal government, they issue wage determinations. It's very clear on the class of employee, and by class meaning what job they're performing on the work site, what they should be paid for work performed on that job. And it typically has two components. One is it's a hourly rate, and the second piece is that there's a fringe. And by fringe we mean it's some type of additional perk, such as time off from work, a 401k match, something like that. It doesn't have to be. It can also be just cash. So you could say, hey, the prevailing wage is $25 and you've got to have fringe up to 10 extra dollars. You can just pay the person the $35. But you've got to pay it and you've got to track it, because on all of those jobs, and I think there are a couple places there are issues. On all of these jobs, you're filling out certified payrolls, and you as the employer need to understand that you are signing and certifying that you are paying that rate, that you are taking the taxes out appropriately. And that's really important, because if the government begins to investigate you, and they look through those certified payrolls, and the general contractor on those jobs is making sure that those payrolls are getting filed, because if there are errors, all money stops to that project, and it stops for the general contractor, and it stops for every sub on that job until it's cleared up. And so most often these things get cleared up pretty quick because people want money still flowing to that job. But where I've begun to see issues with this are where employers have like subs. So I'm a subcontractor to a prime contractor on a project, and I employ a sub as well to do work on that project. And less sophisticated subs don't understand prevailing wage. So if it's a guy who's got a he's a installer of some type on a project, like a tile installer, who's primarily doing residential or private commercial buildings, but this is a public project, they don't normally have all of the administrative background that's required to do prevailing wage. So what I found is if you have those subs working for you, you actually need to go in and educate them. Because look, half this filing has to happen on a computer with, a ton of information provided. And you need to make sure that your sub understands that they are signing off that it's correct. Because I've had a number of times where when my clients dug into it, the subs they were hiring were signing off on certified payrolls, but those weren't what their guys were getting paid.
Yep.
They were not W-2 employees. They were 1099, which was a problem, and they weren't paying that wage. And they on all of these job sites, the Department of Labor and Licensing or the Department of Labor or unions have people walking around the job site asking what wage you're getting paid to make sure that you're paying that prevailing wage. And that's often how they get caught. So it can be a pretty costly endeavor if you don't follow the rules. So if you're going to do a job with either federal or state money, you just need to be prepared to deal with, all of the administrative work that comes with it.
And I'd like to piggyback on that. Unfortunately, the different jurisdictions have different means and systems to report. So it's not a uniform across the country. We have one system that we can go to report this. Is that an accurate statement?
Yeah, each state may do it differently.
Yeah, you have to be savvy with the different systems and programs. And then the second thing I wanted to throw out there is and looking for your verification, but the GC is ultimately held responsible for, as this goes down to the sub and the sub of the sub, so the GC is ultimately held responsible for the certified payroll being correct.
Yes. And that's actually where the pressure comes on the subs to get it right, because as soon as the GC is not paid, the subs aren't getting paid either. And so that can be a bit of a problem. The other kind of twist in this area that we see is the use of a ton of 1099 workers. And they use that a bit to get around undocumented workers. Because if they're your employee, you're doing an I-9, Kathy, which you probably know a ton about with your clients. But if you are hiring someone as an independent contractor, you're not doing an I-9. And so it is a way in which people have been getting around it. But the government, if you really look at it, they're not really 1099 workers. And it's another way that you get into trouble because you're controlling everything about their work environment. They're not 1099s. And what the government comes in and says is, you knew this wasn't a right 1099 job, but you were doing it to use undocumented workers. And now you're in a much bigger world of hurt in terms of the government coming in and digging into you. And and it's just a reality in the construction field. We don't have enough workers. And we don't have enough workers who want to do those jobs. And so we find them in the undocumented worker realm. Those are the people who want those jobs.
Yeah. Before I definitely have some questions around that too. I just wanted to point out that, for the general contractors, making sure during the bidding phase that everybody knows that this job is a prevailing wage and posting what the wages are and whatnot, so that the subs are aware, because I would imagine if you don't bid it with prevailing wage and you won because you're cheaper than everybody else because you're not paying your workers prevailing wage, you can end up losing a lot of money on a project because you're still going to be contractually held to that contract that you signed. So absolutely. Now, obviously, along with that is the idea of undocumented workers. There's knowingly hiring undocumented workers, but then there's also the idea that you may not know, right? Somebody gives you documentation and it's not until it's checked that you would know. So could you, I guess, talk to us both ways? Like, what legal implications do construction employers face when hiring an undocumented worker? What steps can they take to avoid any potential legal risks? What due diligence do they need to be doing to
So
make?
if I could, I'd like to start with, we have the I-9 process,
Right.
and when you have a candidate that comes in and provides documentation, they're signing off that that documentation is legitimate. And so from an HR perspective, the I-9, and they're signing off, we're taking that with the understanding that this is legitimate information. The E-Verify takes it a step further, which is, government work, and they dig a little deeper and it goes into their system, and they'll let you know if the documentation is incorrect, and you have a period of time that you can rectify the paperwork and your documentation. Where the rubber hits the road is when you find out, and I've had this situation before, where you find out that the documentation is not correct and they signed off and they falsified that information. So I guess I'd like to punt that to Suzanne. And in that situation, what would you do, or what would you recommend?
So I recommend that certainly as soon as you have the idea that the employee is undocumented, and then that's where there was a falsification, you need to go ahead and make the termination. You as the employer do not have an affirmative obligation to report them to, I think it's not INS anymore, it's all part of Homeland Security, but you have the obligation to check the paperwork. Does it look like they have a work authorization? Does it look like they have a legitimate driver's license or a social security card? And if that's the case, then you're fine right there. And most documents look legitimate. There's no way to tell whether they're correct or not. It really is the E-Verify that helps the most, because they really can tell you pretty immediately whether the birth date matches, when that social security number came out, and other identifiers. Another, Kathy, you were saying, you kind of find out along the way. We've had employees that come forward after some period of time, like they later become legal and now have like documentation that will support it, but they now go to the employer and say, "Oh, my name before was wrong. I need you to change it, but now I actually have the right documentation." Unfortunately, in that circumstance, the employee's already committed a little bit of fraud and you probably need to part ways. But other ways in which it comes up is if you didn't go through E-Verify, which if it's a non-federal job, you don't have to do. If you just, look at it yourself, you filled out the I-9 form, everything looks legitimate, but you get what's called a Social Security no match letter. And it basically is you've been putting money in for a Social Security number. Social Security comes back often years after the employee's been working there and says, "Hey, this doesn't match up with this employee." My advice is you go to the employee and you say, "Hey, this letter says that your Social Security number doesn't match." Often that employee does not come back any longer. But sometimes you'll hear from an employee, "Well, look, I filed all the paperwork, everything's in process," and they have documentation that permits them to work, a work authorization. And you can help them rectify things with Social Security. But you're on notice as soon as you get that letter that there's something a matter. So before, just looking at the individual's paperwork, you had no idea. But now once that letter comes in, you certainly do. But I mean, people do crazy stuff in this realm. One of my colleagues just recently had one where the employer was paying the spouse of the worker because she had documentation, but he didn't. But he
And
was
he
the
was
one coming to work. He was the one working, but she was getting the paycheck.
Wow.
So I mean, we do crazy things to work around it, but it's all problematic.
We we work with a lot of at MCCI. We work with a lot of schools, and obviously in school there are children in high school who are getting ready to graduate but don't have legal status. They came here with their parents. I think they could be all dreamers or whatnot. We hear all the time, what are these kids going to do? Like, where is there? I have no idea what to tell these high school teachers that are trying to help these students secure a future. What, if anything, can these students do legally to work in America?
So that's a really difficult one. So DACA certainly provides, you're talking about dreamer students. I mean, I believe most dreamers are now like in their 20s, but I mean, there are ways to get status so that you can work, but you've got to have the paperwork to do it. And if you falsify stuff and get caught for it, you're never going to be work authorized in the
Right.
US. And so sometimes it requires you to leave for periods of time. I'm not an immigration lawyer. My colleague Sufen Zhang is, but it is very difficult to find a status that's necessarily going to work. And part of that is going to be from the country of origin that you come from, and what types of things are in place now through the different visa options in order to get status. But for so many of them, you have to leave and come back in unless you're DACA.
Gotcha. All right.
That actually happened with an employee at the general contractor I worked at, where she didn't have the proper paperwork and she left. And when she left, she said, I have to leave for 10 years and then I can come back.
Yeah, similar. I have a friend, similar thing. They didn't leave quite for 10 years because he got married to an American citizen, but it was still quite a hurdle, thousands of dollars and years of him not living here in America. So, all right. Well, I guess, we've talked a lot today about a lot of different things. So, and a lot of different, but primarily in the construction industry, safety is paramount in many ways, like whether it's the safety of their mental well-being or physical well-being. So how can construction employers balance those safety concerns with the rights of workers, particularly in industries where the regulations are so stringent?
First and foremost, Suzanne mentioned early on in this podcast that there should be policies and procedures in place on how you handle safety matters. Oftentimes I find that there may not even be a safety person on site, or possibly a construction company has a consultant that does safety, and there's a disconnect between safety and HR. So I think it's really important that safety and HR, there is some SOP or playbook on, if something happens in the job site, what are the steps that you need to take? I mean, we have to keep in mind the safety of the individual. How do you transport them if they need to go to the hospital? Workers' comp. How do you, get the claim for workers' comp? There's so many different factors. And then if we throw in, oh, by the way, they were, stumbling and they could be under the influence of something, and we've got now marijuana in the picture or alcohol, there's so many factors. I mean, I had one situation with a client where there was a car accident and the woman had a seizure driving and hit a tree, and thank God didn't hurt anyone. But what do you do in those situations? So you really should have a plan and the policy and the best practices on what do you do when something happens.
Yeah, to piggyback on that, OSHA requires certainly OSHA and Maryland MOSH require that you have safety plans in place to make sure that you do know how to respond and that you do report and you have the ability to sort of act quickly when you know that there's been an issue. Uh, I think the hardest part are things that the employer only learns about later. And so, to Kathy's point, how do you make sure there's this reporting that's ongoing, in particular, that HR is made aware immediately, that the supervisor's made aware immediately, so that we know what's happening at that point in time and can react, as opposed to a day later when the employee says, yeah, I was really hurt yesterday, but nobody was around to report it to. I didn't know what to do. So I went to my doctor. So to Kathy's point, they didn't go to a facility that was going to drug or alcohol screen to make sure. And then you're sort of behind the 8 ball on the incident report that needs to go to workers' comp and all the rest to make sure that the employee is taken care of. And there's 2 reasons for that. One, you want your employee to get better and get back to work, right? Because the longer they sit out, the harder it is for them to return to work. I get a little used to the weekend not wanting to work, and I don't want to come back on a Monday. And then, how are you really managing those workers' comp costs associated with it and making sure that workers' comp's going to cover it? Because, workers' comp provides some liability limits for employers, which are a good thing on a construction work site, but only if the employer is following all of its rules. So again, it's always back to the policies, right?
Mm-hmm.
Sure is.
So, with that, what are some potential consequences for employers who fail to comply with employment laws like marijuana legalization, sexual harassment, prevailing wage, undocumented? We've talked about what are some things? What are do you get fined? Do you go to jail? What could potentially happen?
Well, the situation that Suzanne was just referring to, I was actually involved in a case where an individual got hurt on a job site, didn't report it. I don't know, maybe a week later said, oh, my back really hurts. And this was drawn out. It wasn't reported, wasn't documented, it was drawn out. And we had to settle for close to $50,000 to make the case, so we didn't have to litigate and go to court on it. Very frustrating, very frustrating. So, and that was not ill intent from the company's perspective, because this kind of came out of left field. But could they have done things a little bit differently and tighten up? Yes. So that's where the policies and the processes, and you know them in your sleep and things happen. And then as far as the other, Suzanne, harassment and I know exempt status is a big one, and there's a lot of fines with that. I'm sure you can share.
Yeah. So first, I'm going to start by saying, when we talked about the prevailing wage and people not being paid appropriately, those are the largest number of lawsuits that are filed right now. It's that they are not actually discrimination lawsuits. It really is the wage and hour lawsuits where the employees get $100 each, and the lawyers always make money. So the lawyers will get like $150,000. So though, if you're not paying correctly, you're not tracking the time correctly, you're not classifying correctly, that's the risk there. And the numbers can be huge. Discrimination and the other, harassment, if you allow that to go on, look, the damages are, up to $300,000 in emotional and punitive damages, plus the person's back pay. That's under the federal law. There's different caps on the state, but it can be significant dollars. And the problem is, if you don't have the policies in place, it's a lot easier for people to argue that you have a workplace where you allow things to go on. And so where you've got a reporting structure, where you're able to do all of that, it's a lot easier to defend against these claims because everyone's going to get a claim. There's almost no, in our current society, almost no way to avoid getting a claim. And so you want to be in the best place possible to defend against it. I also think it's really interesting, last year, the EEOC, which is the Equal Employment Opportunity Commission, focused specifically on the construction industry and created a whole plan on how they are going to keep an eye on discrimination in the construction industry. So, you just see a lot more focus even by the government agencies on that.
And the moral of the story is to document, document, document. Because if
Yes.
you cross your T's and dot your I's, when that claim comes to you, you have all your ducks in a row to be able to defend it and minimize the risk to the company.
Yep.
Yeah, I sit on a board in which an employee was leaving the board voluntarily, but under duress. Or not the board. They're leaving the organization, and there was that person got a lawyer because there was, and then there was a lot of negotiations made to make sure that a lawsuit did not happen, because the idea of a hostile work environment or anything like that could end up costing the organization a lot of money. So yes, again, making sure that you are covered and that you're documenting things when you do have to let somebody go or they leave.
Right.
Making sure you're well documenting absolutely everything to cover yourself, I think is very important. Appreciate that. So, I mean, so say you are experiencing any of these things and you try to do everything the right way. You're just a business owner, and you unwittingly, or people that work for you, broke some of these laws or regulations. What are some resources or support networks available for them that are either seeking guidance on or helping to rectify a situation that they got themselves in?
I'll start. First and foremost, if you have an HR department, you take those issues to HR. If you don't have an HR department, certainly somebody like myself who's an outsourced company that can assist. But in some cases, those situations are so egregious that for an HR representative and an organization, you should have relationships with people like Suzanne Decker, Miles and Stockbridge, employment lawyers that you can pick up the phone and call and walk through the situation and get support so that you're doing the right thing to minimize the risk and the cost to the organization.
And I'll just say that I think people, sometimes employers, especially small employers who get into trouble, think that they'll keep waiting before they contact counsel. And you actually will save, I think, more money on attorney's fees if you are proactive and either get a Kathy or a me involved pretty early on, because we can help you avoid the litigation and sort of, hey, how can we diffuse the situation? How can we make things better more immediately, and sort of work around and start gathering the information we need to push back, as opposed to if you've let it go on for weeks and months. Sometimes at that point, there's no minimizing what the cost is going to be to fix that. And I mean, I will say that's what I love now, and the difference in sort of employment law from where it was 30 years ago. 30 years ago, it was all defensive. These days, most of it's proactive. Most clients trying to get in front of all of these issues. And a 10-minute phone call is probably going to save you, a lot more time later on.
I think that's some really great advice to wrap up our episode on, is be proactive. Don't let it sit, because I think a lot of people think, oh, I just ignore it, it'll go away.
It
And
doesn't go away.
especially when it involves
Usually.
government, it never goes away.
Correct.
Oh, well, thank you, Suzanne, so much for joining us. I learned a lot on this episode. And I want to thank our listeners for listening to our most recent episode, our third episode of season 2. We hope you enjoyed it as we continue to tackle the construction industry's biggest HR issues. Now you've all learned about the legal hurdles you may face for your organization and how to avoid them, and what to do if you don't avoid them. And join us next episode while we discuss the topic of using apprenticeships to help grow your own workforce. If any of our listeners have a topic or question they'd like us to cover, please share them in the comments. Please check out all the links and resources in the show notes and follow us on social media. That's all for now. See you next time.